The main change to the law, which we saw in the field of corporate governance in 2022, was via the European Union Preventative Restructuring Regulations, which were introduced in July. Those regulations primarily concerned themselves with the European-wide regime on restructuring of companies in financial difficulty, and as such concentrated largely on the examinership process. But what they also did was to amend the Companies Act to put onto a statutory footing the common law duty on directors to have regard to the interests of the creditors of their company, not merely the shareholders, where they regard their company as being insolvent or likely to become insolvent. And whilst the duty has existed for a long time at common law, and so its placing on a statutory footing does not fundamentally alter or increase the duties which directors are under, what it did do, possibly deliberately, possibly not, was to change the point at which the directors might need to bring this duty into focus. And this is because the trigger for the duty being live is where a company is unable to pay its debts as they fall due. Under the common law, that phrase was generally accepted to have its ordinary meaning, that a company simply did not have the cash available to settle its liabilities. However, in bringing the duty under the aegis of the Companies Act, the regulations also brought in the definition of unable to pay its debts as they fall due, which is contained in that act. That definition also includes where a company's liabilities exceed its assets. This is a much less immediate and much wider definition of insolvency, and is not uncommon for companies, certainly those starting out, where their initial expenses may exceed any profit coming in. So while it remains to be seen whether liquidators will perceive that this change in scope gives them further chance to bring claims against directors in insolvent liquidations, it is certainly something which directors need to be aware of, certainly if they perceive that their company is or is facing financial difficulty. The European Union is currently adopting the Corporate Sustainability Reporting Directive, which is expected to be transposed into Irish law during the course of 2023. This directive is in the significant area of ESG, which is likely to become more and more significant over the coming years. And the main thing that it will do will be to expand the obligations on companies to report on matters of ESG from listed companies where they currently sit onto non-listed companies, should those companies be of a certain size. And what this means in practice for directors of affected companies is that those directors will need to be aware of the effect which their company's operations have on environmental, social and governance factors. And they will also have to carry out due diligence, not only on their own company and its operations, but also on what is known as the value chain. That is, its products, its services, its business relationships and its own supply chain. And furthermore, the reporting and due diligence will need to be independently audited. While the directive, when it is implemented across Ireland, will not affect every company incorporated here, directors are likely to face pressure to conduct ESG reporting from investors or from consumers or from other stakeholders, and should consider putting in place robust and effective ESG reporting and diligence processes sooner rather than later.